Hello, everyone. We're going to give folks just a moment to trickle in, and then we will begin. All right, let's get started. Hello, everyone, and welcome. We're very glad to have you all here today. It's now been over a year since Florida enacted SB 1718, an extreme anti-immigration law that impacts a wide range of activities that are part of folks' daily lives in Florida. Immediately after this law was passed, we saw a lot of fear and confusion in communities throughout Florida. And communities have fought back through advocacy campaigns and in the courtroom. So we wanted to bring folks together today so that we can talk about the current enforcement of SB 1718. Now, the goal of this webinar is twofold. First, we want to clear up confusion regarding key sections of this law and current enforcement of these key sections. Second, we'd like to share the ways in which community advocacy and courtroom advocacy is working to mitigate some of the harmful effects of this law. Today, we're going to focus on 5 sections of the law. These sections impact community ID funding, out-of-state driver's licenses, hospital data collection, employment and E-Verify, and quote-unquote human smuggling. First, though, my colleague Amyan is going to provide a bit more background information on the passage of SB 1718.
Hi, all. My name is Amyan Kakou. I'm a staff attorney with the ACLU of Florida, and I serve as co-counsel in the pending litigation challenging Section 10 of SB 1718 with Evelyn and others. So the first thing I'd like to do is talk about the history. Well, I'm going to take about 5 minutes to talk about the purpose and history of and the impact of 1718. Importantly, yes, so the sponsors, as you can see from these quotes, the sponsors of the law describe the purpose of the law as essentially they wanted to create the strongest possible anti-illegal immigration law in the country. That's a misnomer. We've called it the most aggressive anti-immigrant law in the country, and it helps to think about the history of the law to understand why. It's not just an activist slogan. So 1718 is the culmination in a series of border-related measures that Governor DeSantis pushed since 2021, which was the first year of the Biden administration. Some of you might remember that prior to that, in 2018, when he entered the race for governor, he signaled his support for building a wall, but that was under Donald Trump. And in fast forward to 2021, during the Biden administration, when the new administration tried to address the humanitarian crisis that was created at the border by Donald Trump's really cruel border policies, in September 2021, the governor issued Executive Order 21223, which was really, aside from making life extremely difficult for unaccompanied immigrant children and the shelters that care for them and a number of other measures, served really as a precursor to 1718, and specifically in three ways. And again, I'll try to go as quickly as I can. Number one, it directed state agencies to collect information about healthcare costs that could be blamed on trigger alert illegal aliens. And secondly, it directed state law enforcement agencies, so that's the Florida Department of Law Enforcement and Florida Highway Patrol, to use traffic enforcement to find and detain illegal aliens suspected of having been transported into Florida from the southwest border. Crucially, the order defined illegal aliens extremely broadly to include essentially anyone who lacks lawful status. Now, if you are familiar with the jargon of immigration law, you will know that there's a difference between lawful status and lawful presence. Lawful presence can refer, for example, to an individual being paroled into the country. We have a lot of parolees, obviously, in Florida. It can refer to someone who is awaiting a decision on an adjustment of status application or green card application. Lawful status refers to having a visa, having TPS, notwithstanding some of the comments we've heard recently about TPS in national politics. And so it became very clear that the goal of the executive order was really to challenge what, in fact, the executive order was called the Biden border crisis executive order. But it was intended to challenge the authority of the federal government with respect to immigration, and also to essentially tag undesirable immigrants as illegal. So this is an important background. The second measure was in 2022, SB 1808, which essentially penalized public transportation companies that helped the federal government resettle unauthorized aliens into Florida. And here again, unauthorized aliens was very broadly defined, and also vague, a rather vague use of the term that was not very well defined in the law itself, and that is generally not very well defined in the Immigration Nationality Act. Importantly, 1808 it was in connection with 1808 that the governor was able to obtain a budget to fly migrants from Texas to Massachusetts. You might remember that was in late 2022. And then another important point in 2022 was that the governor was able to get a grand jury impaneled to essentially to come up with new ways to keep undesirable migrants from Florida. And the grand jury obliged him. It certainly helped that the governor was able to provide information to the grand jury based on the very misleading information that had been collected pursuant to the executive order from 2021, which I mentioned earlier. And so the recommendation of the grand jury at that point was to amend the then existing human smuggling statute. I'll come back later to when I discuss Section 10 to what the content of the previous version of the law was. But the recommendation of the grand jury was, in essence, to make it a felony not only to transport undocumented migrants across state lines into the state of Florida, but also to transport or harbor them anywhere within the state of Florida. And here again, undocumented immigrants were or the target population was defined extremely broadly to include not only individuals who had entered the country unlawfully, but also individuals who had entered the country lawfully, but who had overstayed their visas. All right, and so that recommendation became the basis of a legislative proposal that Governor DeSantis expanded by adding, again, based on the information that was collected through the executive order, the 21223, that was expanded to include a requirement that hospitals collect immigration status information from patients, stronger e-verify requirements, and new limits on issuing or recognizing licenses, driver's licenses and identification cards issued to undocumented immigrants. Fortunately, and as I'll discuss also a little bit later, the final version of the law was a little bit watered down, at least with respect to that the specific with respect to Section 10, which is the again the quote unquote human smuggling provision, and that again was thanks to the work of immigrant advocates around the state, but in the end, it's very clear that the breadth of the law tells you that it despite being eventually watered down from the initial version of the bill, the breadth of the law definitely made it the most aggressive anti-immigrant law in the country. And I think its history and design really shows that the purpose of the law was, not only a cynical attempt to score political points against the Biden administration, but really to sow terror and confusion in immigrant communities, as Evelyn mentioned up top. Governor DeSantis called it to disincentivize immigrants from coming to the state, but also to, in a certain way, incentivize those who are already in the state to leave. And unsurprisingly, that is the reaction that a lot of people had. And by the time the law came into effect in July 2023, there were increasing reports of immigrant workers leaving or planning to leave the state in a way that actually threatened to hurt the state's economy, just as, again, immigrant advocates have predicted. And so that's when, so let's see here. All right, and so that's when essentially the supporters of the law, I wonder if we should get to the next, apologies, Evelyn, if we should get to the next, oh, okay, yeah, never mind, that's fine. And so that's when the supporters of the law essentially began to seemingly backtrack, or at least to speak out of both sides of their mouths. Some, going as far as pretending that the law had no teeth, but again, proving that the law is extremely short-sighted, or at least incredibly dishonest, and not just cynical but spiteful. But again, as Evelyn said up top, we are fighting back, and part of fighting back is cutting through the confusion, and so that's why we're here today. And I'll be happy to answer additional questions later about the history of the law if necessary.
Thank you, Amyan. I'm going to talk about sections 1, 2, and 3 of SB 1718. First off, I'd like to introduce myself. My name's Evelyn Weiss, and I'm a litigation attorney with Americans for Immigrant Justice. I have been very fortunate, and Americans for Immigrant Justice has been very fortunate to work in coalition, both in the lead up to and after the passage of SB 1718, with a number of community organizations, both throughout the state and throughout the country, to help fight against this harmful law and to mitigate its effects. My colleague Amyan from the ACLU of Florida and Renata from FLIC have been two of those who we have been very fortunate to be collaborating with and working in coalition with as we fight the harmful effects of this law. Now, sections 1 and 2 of SB 1718 are the first ones that I'm going to be discussing. And these sections deal with community funding for with funding for community identification documents. Now, these sections bar counties and municipalities from funding identification documents for individuals who don't provide proof of lawful presence in the US. Here, it's important to note why community IDs are important. They're important for folks who don't have documentation in the US, for folks who don't have lawful status in the US, and they're also important for those who are unhoused, for folks who lose their ID, for students, basically for anyone for whom whatever reason can't get the documents they need to get certain forms of government identification. Now, we should also note what sections 1 and 2 of SB 1718 don't do. They don't invalidate or have any effect on the validity of ID documents or ID cards for folks have obtained without showing proof of lawful presence in the US. You can still use these IDs. At its core, these sections are about funding, and they cut off county and municipal funding to organizations providing community IDs without proof of lawful presence. Being cut off from government funding hasn't stopped nonprofits from issuing community IDs, though. For example, Branches is issuing community IDs for Broward County and Miami-Dade counties, and Human Rights Coalition of Alocha is issuing community IDs as well. One way to support community IDs is to help fundraise and donate to organizations that are continuing to provide these IDs. Here, it's important to note that SB 1718 is not, however, the only law that impacts community IDs. There's also HB 1451. And HB 1451, which was passed in Florida which was enacted in 2024, prohibits counties and municipalities from accepting as identification any ID card or ID document issued by an organization that knowingly issues IDs to individuals who are not lawfully present in the US. And this law went into effect on July 1st, 2024. Now, on the face of this law, it shouldn't have an impact on whether counties or municipalities can accept community IDs issued by organizations that do not ask whether individuals are lawfully present in the United States, since the law only prohibits counties and municipalities from accepting IDs issued knowingly that the ID holders are not lawfully present. Now, even if folks find that their community IDs are no longer accepted by a county or city government, it's important that we note that there is no penalty for possessing or presenting community ID cards. And even if certain places, counties, municipalities, don't accept community IDs going forward, that doesn't make them invalid in all places. And this is something that it's important for community members and those who represent them to be aware of, that there is no penalty for possessing community IDs, neither HB 1451 nor SB 1718 have any impact on penalizing or barring possession of this type of ID. Turning to out-of-state driver's licenses, which is section 3 of SB 1718, this section invalidates out-of-state driver's licenses that are part of a class of licenses exclusively issued to undocumented immigrants who can't prove lawful presence in the United States. And driving with an invalid driver's license could result in a second-degree misdemeanor, punishable by up to 60 days in jail and a fine of up to $500. Now, it's really important to note that currently this law only affects driver's licenses from Connecticut and Delaware, and we have heard few accounts of it being enforced. Here, we should note that initially there were fears that this law could apply to up to 19 states, which issue to the driver's licenses of up to 19 states that are issued for folks who cannot prove lawful presence in the United States. And shortly after SB 1718 took effect, the governor and Department of Highway Safety and Motor Vehicles announced that 5 state driver's licenses were invalid under the new law. Although we can't know for sure what drove changes to this, advocates did reach out to other state departments of motor vehicles, and the list started to dwindle. Now it's only 2 states, Delaware and Connecticut. Now, it's very important for folks who have out-of-state driver's licenses to be aware, and for those of us who provide advice to the community to inform them that the fact that it is just Delaware and Connecticut right now doesn't mean that this is going to be the case forever, and that it's very important to check the Department of Highway Safety and Motor Vehicles website to see which states driver's licenses are currently barred. Currently, Delaware and Connecticut, but this is subject to change. And should it change, community advocates will be continuing to investigate and advocate. So this is an important thing to be aware of, an important thing to check, but much of the harmful effects of this law, this section of the law, have in fact been mitigated, given that the initial fears of 19 states being affected and the initial 5 states that were listed, and now we are down to 2 states' driver's licenses. And it's important to note as well that these are just the driver's licenses for folk that have been issued to folks who did not provide documents showing lawful status in the US. I'm going to turn it over to Renata to discuss hospital data collection.
Thank you, Evelyn. Hi, everyone. I am Renata, Deputy Director of the Florida Immigrant Coalition. And it's absolutely an honor to share space with advocates who made SB 1718 much less impactful and harmful as it could have been. And one of the issues is the data collection provision that requires hospitals that receive Medicaid to inquire patients about their immigration status in the admission or registration forms. So unfortunately, when that was announced, it already created a lot of fear with our undocumented community that already lacks access to preventive care for various reasons, including affordability and the difficulties of securing health insurance. It is a community that relies on emergency care when care is already needed, urgent, and necessary. So when hospitals started collecting data on status, that created several tensions for us. But in the proposal for SB 1718, we did a lot of advocacy to make sure that patients would have the opportunity to decline to answer to that question. And today, the law requires that when the immigration status is asked, patients do have the opportunity to decline to that question, and that has been the core of our education. The law also requires that hospitals report through aggregated data quarterly to the Florida Agency of Healthcare Administration, and that they submit a report where you can see it's absolutely cruel and political. They can send a report to the governor, to the Senate president, and the Speaker of the House of the total number of visits for the calendar year that were given and the cost related to, particularly to trace or estimate the cost of care given to undocumented migrants. It's important to say that the data from 2024 shows a dramatic decline in Medicaid dollars that were spent towards emergency coverage for immigrants in Florida. We, of course, continue to investigate if that means individuals being concerned and deterred from achieving care, or individuals really being, the cost being really minimal vis-a-vis the cost that it's spent with the overall population. But we know that a lot of education is still needed. If we can go to the next slide. So that is the core of our campaign. is that the law requires the hospitals to ask the question, but gives patients the capacity to decline. So not only anyone can refuse to answer the question about immigration status, we rather recommend that everyone declines to answer, regardless of them being an American-born citizen, an immigrant with a vulnerable status, or a legal permanent resident. It doesn't matter. The law does not modify that emergency care is protected by EMTALA. The law does not modify the access to an interpret in native language. And the law does not modify that people have the capacity to decline to answer their status. The last thing that I should say is that the report that has been produced for the legislature with this ACA costs, Florida Policy Institute did an analysis about the dashboard that was created with that data. And very puzzling, the report shows a huge discrepancy in numbers. The report that was sent to the legislator shows, for example, that it's about 600 million spent with undocumented immigrant care. But in an analysis and breakdown from the Florida Policy Institute, the estimate is below 20 million. So it also raises flags on the political intent of the law. So we do want to make sure that we are educating the community so politics don't get on the way of getting care when it's needed. And I can pass it back to you.
Thank you, Renata. I'm going to discuss sections 6 and 7 of the law, which deal with employment and e-verify. Now, these sections create penalties for businesses that employ unauthorized non-citizens. They use a different term, which I will not be using, and mandate participation in the e-verify system for both public agencies and for private employers that employ 25 or more employees. Now, these e-verify checks, per the law, must be done within 3 days after a new employee begins work. The section also imposes a $1,000 per day fine for out-of-compliance employers who the government's department or the state's Department of Economic Opportunity determines failed to use the e-verify system as required 3 times in a 24-month period. Non-compliance can also lead to the suspension of licenses for employers until the non-compliance is cured. And there's a series of ratcheting penalties on employers that have been created by this law for both failure to use e-verify initially when employees are hired, and also for knowingly employing folks who do not have authorization to work after being made aware that they no longer have or lack work authorization. Now, this law also criminalizes employees who use false IDs or who use someone else's ID to get work. And this law creates a 3rd-degree felony to use a false ID or someone else's ID to secure employment. Now, those of us who work in the immigration field are all fairly aware that e-verify is very far from perfect, and that it can issue incorrect mismatches or non-confirmations indicating that someone does not have authorization to work despite the fact that they actually do. And if you or your client finds themselves facing a mismatch, a tentative non-confirmation, which is called a tentative non-confirmation, they must receive the opportunity to take action. Employers, this is very important to note, employers may not suspend, terminate, delay training, withhold or lower pay or take any other action against employees because of a mismatch until it becomes a final non-confirmation. And if if an employer erroneously refuses to hire someone or dismisses you or your client based on inaccurate E-Verify results, or if you have concerns about a tentative mismatch that is not being corrected, you can call the Department of Justice Immigrant and Employee Rights Section hotline. And we've provided the number for this hotline. We encourage using this hotline if folks find themselves out of work due to errors with E-Verify. This is a serious problem that affects folks' livelihood, and the use of a system that tends to have errors means that folks will need to take action and self-advocate if these problems occur. With that, I'm going to turn things over back to Amyan to talk about the quote-unquote human smuggling section of this law.
Thank you both. All right, so Section 10 amends and expands Florida's human smuggling statute. All right, let me tell you a little bit about the previous version of the law. Previously, Florida made it a crime to transport into the state people who were caught in the process, or I should say people who assisted or transported into the state of Florida, people who were in the process of illegally entering the country, meaning people who typically were arriving to the U.S. on Florida coastlines, from places like Cuba, Haiti, et cetera, an old story. That law was problematic, but was a little bit more in line with the very narrow construction that federal courts had given to the federal human smuggling statute, and it also makes intuitive sense, right? Smuggling is about assisting someone in helping someone cross into the country unlawfully, and yet I mentioned earlier the executive order 21223 that directed state law enforcement agencies to be essentially on the lookout for individuals who were being transported from the southwest border. In implementing that executive order, we found out eventually that Florida Highway Patrol tried to use that law to arrest people. In fact, they arrested or at least charged dozens of people between 2021 and 2023, I guess, when the law was eventually amended. But a lot of those cases, a lot of those charges had to be dropped because, again, we're talking about people who are in the process of entering the country, not people who are entering Florida from other states or driving here from the southwest border or wherever else. So again, here the point of the amendment was to expand the concept of human smuggling beyond even the federal definition of the term. And so that's very important. So now with the current version of the law, I said earlier that the initial bill included provisions that were broader in terms of making it a felony to transport someone into the state, but also to transport an undocumented person within the state, and also made it a crime to harbor people within the state of Florida. Fortunately, again, thanks to the work of immigrant advocates, the terms of the law were narrowed down slightly, at least where the
I believe, Amyan, did your internet just...
documented person within the state of Florida, or to have them stay with you. Uh, oof, I'm
Jan, I
getting
think we may have lost you for just a moment. Would you mind
yes.
repeating
I
from where I believe you were just beginning to talk about the persistent advocacy that narrowed this law, the scope of this law?
Oh, okay, thank you. Yes, I just saw a sign saying that my connection was unstable. Apologies. So yes, so again, thanks to advocacy, we were able to narrow some of the terms of the law from prohibiting or making it a felony or a crime to transport people within the state of Florida or harboring people within the state of Florida. And now the current version of the law only makes it a crime to transport people into the state of Florida. So again, it's not a crime to drive an undocumented person within the state of Florida or to have them stay with you. And so this interpretation is very clear from the text of the law. And for what it's worth, it was confirmed in the course of litigation by attorneys for the state. And, in the handful of cases that have been prosecuted since the law came into effect, that's also been the consistent understanding or its consistent interpretation. At the same time, the law remains very broad in terms of time, meaning it applies to anyone really who has ever entered the country illegally and not been inspected. And again, that term inspected is quite broad and vague. It's a term of art in immigration law. It's been litigated. It's not always clear what interaction between the federal government and the individual would qualify as an inspection. And again, the lack of clarity was very deliberate, right? It was about disincentivizing as many undesirable immigrants as possible. But, I will mention very briefly that, in the course of litigation, again, this is not worth a lot, but in the course of litigation, lawyers for the state try to argue that sending an immigration application could count as an inspection. But again, the judge was appropriately skeptical. But still, I'll give you just quick examples before moving on to the workings of the law. The examples of individuals who might be potentially impacted. So typically those categories are workers and families. There may be other categories, but workers, people who are being driven into the state for, for construction jobs or farm work. There's a reason why one of the plaintiffs in our lawsuit is the Farm Workers Association of Florida, which is an organization whose members cross in and out of Florida multiple times each year for seasonal work. We also have families or individuals with families who might be impacted as plaintiffs. So, for example, we have a U.S. citizen grandmother who has family members in Georgia, and who regularly drives across state lines with her grandson, who's undocumented. And we have, other, at least one other, if I remember correctly, plaintiff in a similar position. But we also have other categories. We have individuals who assist undocumented immigrants who, for example, may need, medical care or may be attending an immigration appointment in Georgia or in Florida and needs to cross state lines. So all these individuals are unfortunately impacted by the law. But again, it's important to stress that the law does not apply to everyday errands within the state of Florida. All right. Now, the way the law works, it makes it a third-degree felony, which means up to 5 years in prison and $5,000 fine to transport someone into the state of Florida. This gets bumped up to a second-degree felony, up to 15 years in prison, and a $10,000 fine under 3 circumstances. One, if you are transporting a minor into the state, so that typically means what they would call an unaccompanied immigrant child, whether or not there's a parent. Number 2, if more than 5 people are being transported in a single episode. And number 3, if you have a previous conviction for the same crime. So this is, in essence, how the law works. I'm going to tell you quickly now about the status of the lawsuit. So in May, the lawsuit challenging this specific section, which is Section 10. In May, our Judge Roy Altman, I'll mention that, he's a Trump appointee. But in May, Judge Altman issued an order temporarily blocking the law. So he ruled that Section 10 is strongly likely to be found unconstitutional because of very well-established legal precedent, not just in our jurisdiction in the 11th Circuit, but across jurisdictions, really. And essentially the precedents tell us that only the federal government is allowed to regulate immigrant transportation. States can get involved, but only within the limited scope authorized by federal law. But as I mentioned earlier, SB 1718's definition of human smuggling really goes beyond the federal government's understanding of human smuggling. Now, the state did not really, in the course of litigation, did not really contest the precedent, but they tried to essentially get around it in some manner. But again, the judge didn't buy it. Now, subsequently, there was a little bit of confusion because the judge issued a ruling, a supplemental order, which essentially asked the parties to provide legal arguments as to whether or not the law should continue to be blocked statewide, so that the state would remain prohibited from arresting anyone anywhere for human smuggling while the case is pending, or whether the scope of the order should be limited to the plaintiffs in the lawsuit. We've argued essentially that it would be extremely impractical and unusual to rule that the law is likely facially unconstitutional, but allow it to apply to people who are not before the court. And then separately, the state filed a motion asking the court to reconsider whether the plaintiffs are allowed to sue to block the law based on the preemption principle, which is the principle articulated in precedent, as I just discussed. So it's a very arcane argument. It's novel from my perspective and fringe. So I know this is being recorded, and so I'll say it on the record. I'm not too worried about it, but I'll knock on wood. But anyway, this is where we are now with the lawsuit. We are awaiting the judge's ruling on these filings, and we're monitoring what's happening in the courts and in the field to make sure that no one's getting arrested or prosecuted under this law while it's blocked. That completes it.
Thank you so much, Amyan. So we solicited questions in advance, and we're going to have a short question and answer session answering some of the questions from participants today. First off, though, I have a question for Amyan, just to wrap things up. Now, can Section 10, the quote-unquote human smuggling section, be enforced anywhere in Florida right now, in any county that borders? Can anyone find this section enforced against them right now?
Well, only people who are essentially caught driving across state lines into Florida. Now, it doesn't mean that a person would be arrested only if they're caught or seen crossing state lines. At least that's not been the interpretation thus far at least the interpretation that prosecutors or at least law enforcement has given the law. We've seen people be arrested in Sumter County, Hernando County, Columbia County, Pasco County, certainly Santa Rosa, which is closer to the state border with Alabama. A lot of arrests in Jefferson County. Not a whole lot of arrests further down south, which makes a lot of sense. Typically, we're talking about people who have been driving or who are suspected of driving from out of state, essentially nonstop. So again, it would not apply to you if you're just leaving your house. You have a cousin who's undocumented and you're stopped by law enforcement. That is not human smuggling. They can keep stretching the definition, but that would be insane, to use a technical term.
Thank you. So Section 10 only applies crossing state lines into Florida. And now, in light of the judge's injunction, in light of the judge's preliminary injunction, can folks now do folks need to be worried about being arrested, being prosecuted for violating this law right now?
Currently, no. They should not be. The law is blocked statewide. As I said, there was a subsequent order, and so there is a little bit of a cloud of uncertainty as to whether or not the law will remain blocked statewide. Again, I'm very optimistic, but for now, the law is blocked statewide. So that means no one should be arrested for human smuggling under Florida law for now.
Thank you. And before we move on to our next question, I think this is a good moment to note for members of the community and for advocates out there that this is one of two sections of the law where we'd like to urge you to look for current information before giving advice and before making a decision about the risks that you face. The other section of the law is Section 3, which invalidates out-of-state driver's licenses. As we've said, right now, that only applies to Connecticut and Delaware driver's licenses, but we cannot guarantee that that will be the same moving forward. And so it's very important to check for current information on the Highway Safety and Motor Vehicle website for the state of Florida. To confirm this, they provide a list of driver's licenses, and this list has changed. The list has only gotten shorter, but it has changed in the past since the enactment of the law. So it's very important to maintain current awareness before giving advice or before making a decision about the risk that you are choosing to bear. Section 10 right now, as Amyan stated, is preliminarily enjoined, so cannot be enforced right now. But we unfortunately cannot guarantee that that will be the case going forward, although all of the attorneys working on that case, which includes the ACLU of Florida, Americans for Immigrant Justice, the American Immigration Council, the ACLU's Immigration Representation Project, we are all working to ensure that this is the case going forward, but we cannot guarantee that this injunction will stand. So it's important to maintain an awareness of the current information. Now, the next question was posed by one of the participants in this webinar, and I'm going to ask Renata to address this one. They asked, what role does HIPAA play in this law?
So in regards to hospital data collection, the hospitals are only required to share aggregate data and to not disclose personal identifiers, right? However, this could be potentially further investigated with a public records request because of the context in which we live in. But hospitals should not be disclosing personal identifiers.
So, and I apologize, I should have stated what HIPAA is. HIPAA is a federal law related to the privacy of folks' information. And so this question bears on, do folks, and I think at the core of it is, do folks need to be concerned about their private information, including their immigration status, being shared more widely with the government? And Renata is shaking her head. So that is
They should not be concerned. And we really want to educate the community that healthcare comes first. Nobody should have the fear of seeking health care when they need it the most. So that data should not be disclosed. But we should absolutely, through public requests, right, to investigate, to make sure that it's not being disclosed in any shape or form.
Wonderful. And to hospitals, I just want to flag, hospitals also are required to inform folks that their information will not be shared with immigration authorities, that immigration enforcement is not part of the point of this data collection. As Renata has stated, we are urging everyone, whether you're a citizen, whether you have any sort of lawful status, or whether you don't have lawful status, to decline to answer, so that we are not providing data to support this, and so that folks can feel more secure knowing that this section is not having any impact. But even if folks note that they don't have lawful presence in the United States, hospitals are required to state that this information will not be provided to immigration authorities. And that's information that we think it is extraordinarily important to share with the community and for advocates to share with their clients. The next question I'm going to address very briefly, and that is, are there any changes to the law since it became effective? And here I would flag that there are two big changes to the law since it became effective. One is thanks to a lawsuit filed by ourselves and a coalition of organizations. Section 10, the quote unquote human smuggling section, is preliminarily enjoined, so the state cannot enforce it. The second change that we have seen in enforcement has been the limitation on the applicability of the out-of-state driver's license provision. So those have been the big changes in changes to the law since its effective date that we have seen so far. But we can also say that advocates have been working to mitigate other harmful effects of this law, because it is an extremely wide-ranging law, and we are working together to determine where it is having the largest effects and where we can pursue further fights against this law, because to fight to protect and defend the rights of Florida's immigrant communities. Now, the next question I'm also going to address, which is how to provide someone asked how to provide legal advice to clients regarding the new law. And first, I would state that because this law is so wide-ranging, because it touches on so many different aspects of daily life, it's really important to learn from your clients, what are they concerned with? What aspect of the law do they need advice on? Does it deal with employment, travel, seeking medical care? And to tailor the advice based on what folks are seeking advice on, and then also their personal immigration status and immigration history. So it's really important for folks to consult with immigration attorneys if they have particular concerns about this law. That is the best way to get personalized, tailored advice to your individual situation. I'd also like to point folks to know your rights information that Americans for Immigrant Justice has shared to give a broader sense of the different ways in which this law can and cannot impact folks. We have a number of Know Your Rights flyers that deal with all different aspects of the law on our site, aijustice.org. That's aijustice.org, and you can turn to 1718 resources to find Know Your Rights that are more general information sharing in the community. FLIC has also been a leader, as has the ACLU of Florida, in sharing out information on how this law can impact folks and how it cannot impact folks. So we advise kind of always the best advice that one can give is personalized advice from an immigration attorney. And community empowerment and education can be provided through information sought on available on our website and information shared by other organizations. But we'd urge you to look to that to provide advice to folks. We're going to wrap up right now, but I want to thank everyone for attending. And if you have any questions, you are always welcome to reach out to our organizations. I believe that is true for all three of us. And we will continue the fight to defend and expand the rights of those in our immigrant communities and fighting against harmful laws like SB 1718. We will continue the fight against this law and future laws like it.
Thanks for organizing, Evelyn, and thank you all.
Thank you.